Zariah Benton pushed open the heavy courtroom door at exactly 8:57 a.m., her sneakers squeaking softly against the polished floor. She wasn't late. She was timed, 3 minutes early, just enough to walk in without rushing while still making a statement. Black Converse, charcoal slacks from a resale app, a faded navy blazer with the sleeves rolled to her elbows, her box braids pulled into a low, neat bun. No makeup, no jewelry, no attempt to look older than her 19 years. She carried only a thick binder, no laptop, no flashy briefcase. As court was called into session, Judge Lennox sat up a little straighter as she passed the bar. She took her seat at the defense table without a word and flipped her binder to a tab labeled, Kilroy Cross. The opposing attorney glanced over, confused. "Ma'am, this table's for counsel." "I am counsel," she replied, not looking up. He studied her again, unsure whether to laugh or worry. From the witness stand, Officer Dennis Kilroy, white, mid-40s, arms crossed, the kind of man who wore mirrored sunglasses on cloudy days, smirked and muttered to the court officer beside him, just loud enough to be heard. "What is this, debate club?" A few scattered laughs rippled through the gallery. Zariah didn't blink. She clicked her pen once, wrote a single note, and waited. When the judge called for cross-examination, she rose, and her voice didn't waver. "Defense is ready to proceed." She walked to the witness stand unhurried, as if she'd done this 100 times, though it was only her 3rd time in open court. "Officer Kilroy, how long have you been on the force?" 23 years, he said, smirking. "Then you're familiar with standard protocol during traffic stops." "Obviously." "Good. I'd like to walk through the one involving my client on April 6th. The room shifted. Kilroy rolled his neck. "You mean the guy who ran a stop sign and got mouthy?" She nodded, confirming the time and location, and asked whether his body camera had been active and whether that footage had been submitted. It had. With the judge's permission, she began referencing it directly. She produced a still from his own footage, timestamped 4:49 p.m., showing 2 SUVs partially blocking the stop sign from his sightline. "Could you clearly see whether my client came to a full stop?" she asked. "I judged it the best I could." "Not what I asked. Could you clearly see it?" "Not completely, no." She moved to the audio, where Kilroy had called the driver, twitchy, probably high. No field sobriety test had been conducted, no drug screening requested. "So your conclusion was based solely on him fidgeting?" Kilroy shrugged. "I've done this a long time." Her client had been stopped, searched, and cited on nothing more than a feeling. She pressed further. His report claimed he'd observed a bag under the passenger seat, but the footage showed him asking, "What's in the bag?" without ever crouching down or using a flashlight. "I saw something dark. I assumed it was a bag. But you wrote that you observed one." "Maybe I was mistaken." Then she asked whether, in 23 years, he'd ever been formally disciplined. After a pause and a prompt from the judge, he admitted to one excessive force complaint a decade earlier, later dropped. Reading aloud from the department's procedural manual, she noted that stops must be justified by specific observed actions, not instinct, and that fidgeting, glancing around, and looking nervous were not illegal behaviors, and no weapon, contraband, or threat had been observed before the search. Yet in the footage, Kilroy had said the driver, "fits the type, always act the same way when they've got something to hide," later adding he'd jumped like a rabbit, just like the last kid. Zariah introduced a nearly identical report from 6 months earlier, same precinct, same language, involving another young black man who had been detained despite nothing illegal being found, and against whom a complaint had also been filed and not dropped. "Is it standard for you to repeat descriptions across incidents when no violation occurred?" "I don't know," Kilroy mumbled, then admitted, "maybe I rely on pattern recognition." "That's not what the department calls it," she said. He snapped back, "Sometimes you get a feel for who's hiding something." She let the silence sit before reminding him that department policy didn't accept feelings as grounds for a search. Turning to the judge, she argued that the stop lacked legal grounds. The officer had misrepresented his sightline and relied on subjective language with no supporting behavior. Then, without raising her voice, she asked one final question. "Did you know my client is a high school math teacher?" Kilroy's head jerked back. "No. You didn't ask. Did you ask where he was coming from or going to? No. Didn't seem relevant. She laid it out plainly. The stop, search, and citation rested on a rolling stop he couldn't clearly see, a bag he couldn't identify, and a twitch he'd assumed meant guilt, all without ever asking who the man was. You saw a young black man in a hoodie driving a used Camry and decided the story for him, she said. Maybe this guy had a long day teaching 6th graders how to convert fractions. You thought he fit the type. That was all you needed. She told the judge she wasn't asking for pity, only truth. This case wasn't about a stop sign, it was about lazy, harmful assumptions. In her closing argument, she reminded the jury that the footage showed no threat, no resistance, no probable cause, only a teacher driving home and an officer's feeling. Feelings aren't evidence, she said. They don't give you permission to rewrite facts. Her client, she said, had been profiled and humiliated because no one bothered to ask who he was before deciding what he was. The prosecutor's closing, by contrast, was brief and forgettable. After 70 minutes of deliberation, the jury returned a verdict of not guilty on all charges. Kilroy stared ahead, stunned. Her client, Devin Rials, turned to her with shaking hands. I thought this was going to bury me. She smiled for the first time that day. You're standing. That means they lost. Outside, reporters were already waiting. Asked how it felt to win a case like this at her age, she said simply, I'm not here to feel good. I'm here to make things right. She didn't yet know that a clip of her closing argument had already begun spreading online, and by evening, it had passed hundreds of thousands of views, with people asking who this 19-year-old was who had dismantled a 23-year veteran without ever raising her voice. That night, as her inbox filled with interview requests and messages from strangers, Zariah stayed quiet. She didn't want fame. She wanted the system to stop giving officers like Kilroy the benefit of the doubt while withholding the benefit of the truth from people like Devin. Across town, Kilroy sat alone at a bar, watching the clip on someone else's phone, saying nothing. By the following Friday, after his footage and record came under formal review, he was placed on administrative leave. Zariah went back to her small apartment near campus, back to cereal eaten out of a mug and handwritten notes, replying to messages from people she'd helped before and from strangers who said her closing argument had given them hope. Days later, she led a youth workshop, telling a room of high schoolers, you're going to walk into rooms where people think you don't belong. Don't waste time proving them wrong. Prove yourself right. When a student asked how she stayed calm while people laughed at her, she answered, because they laugh when they feel safe. I don't give them that. It wasn't theater, she told them, it was justice, just dressed differently. You didn't need to shout. You only needed to show up prepared and let the truth do the rest.